All right, good morning, everybody, and thank you for joining us for another webinar with the South Florida Manufacturing Association. Today, we are happy to introduce Christina Paul of K&L Gates, who will be presenting on manufacturing warranties under the Federal Magnusson Warranty Act. If you heard just a couple minutes ago, we'd like to go through the list of everybody who is on the call just to tell us what kind of business you're in today so that Christina has a good feel of who she's talking to and what things you might be interested in. So whoever wants to kick that off, please go ahead and do so.
Can you hear me?
Yep, we can hear you,
Yes.
Wendy.
Okay, all right. This is Wendy Cohen. I'm with ACR Electronics. We manufacture emergency beacons.
Thank you, Wendy.
Skip Lindemann. Oh, I'm sorry.
I was just going to say, this is Kat, and I'm also with ACR Electronics, and we actually use K&L Gates in the UK for some of our distribution efforts over there.
Thank you and welcome.
Thank you.
Skip Lindemann. I'm with Huron Machine Products and Decimal Engineering. Huron, we manufacture top jaws for the turning industry, and Decimal Engineering is a large, complete sheet metal fabrication company.
Welcome, Skip.
Thank you.
It looks like the only one we haven't heard from is Chuck Lowell with Tough Skid.
Okay. All right, so do you want to go ahead? Should I start? And
Yep, I think go ahead and start.
yeah, if people join late, that's fine too. So good morning, everyone. Welcome. Thanks for attending this webinar. Let me just start off by saying that I mentioned it earlier, and I'm not sure if everyone heard. If you have some specific questions as I'm going through this presentation, please feel free to ask me. I'm happy to stop, address anything. If we need to take a detour off the PowerPoint, I'm also happy to do that. I imagine that you might have some specific questions, so we can cover that. So let me just tell you a little bit about me. Obviously the picture's pre-COVID, but I have been practicing law for 18 years, just about 18 years. Most of my business is in the warranty and consumer litigation space, which means that I represent generally manufacturers and distributors of various products. Most of my business is centered around the marine industry, but I do other industries. I do some transportation and logistics as well, and I've been doing that for quite a long time. So I'm very familiar with the terms of warranty. I'm very familiar about how they're enforced, certainly within Florida, but also my practice extends beyond the borders of Florida. I actually have and continue to practice nationally and internationally. So I have a pretty good breadth of this area and happy to address any questions that you have. So the outline today is I want to give you a basic introduction. It's not meant to bore you, but it is meant to sort of define what this act covers, the Federal Magnusson Act. I want to talk to you about how you can convey the warranty, different ways that you can do that because there has been some changes in legislation. I also want to talk to you about some key terms to include in a warranty. We'll go over some scenarios that commonly trigger lawsuits. We can talk about the types of claims that arise in those types of cases, and we'll go over a couple of those examples. And then we'll talk about what the implication is to you as either manufacturers or distributors and what you need to perhaps be aware of, and just some tips to help you in your business to perhaps avoid some of the pitfalls. So the Magnusson Warranty Act was actually enacted quite a long time ago, back in 1975. It was put forward by 3 Democratic senators that wanted to see this bill pass, and it was sort of championed by them. The purpose of it was to protect consumers. The goal is to govern warranties on consumer products and make sure that the consumer has rights that they can assert, under these warranties or pursuant to the warranties. It doesn't require each product to have a warranty, and that's a common misunderstanding with lots of manufacturers. Just because you manufacture a product does not mean that you have to issue a warranty. But if you do issue a warranty, you need to comply with this act, whether it is a full or a limited warranty. And the law really came about, as I mentioned, because there was some concern that consumers weren't getting the benefit of their dollar. So, years ago, we've seen the Electrolux, delivering salesmen to the door, and he's delivering that vacuum. Well, the vacuum goes kaput in 30 to 60 days, and what type of warranty was provided? I don't know if it's the Electrolux cases or products, but it's that common notion that people seem to not have appropriate remedies, and manufacturers were not supporting their products essentially after saying that they would. So the Magnusson-Wasp Warranty Act tries to address consumers who have been injured by a supplier's non-compliance. And it allows them, the actual consumer, to bring an action in federal court if the amount in controversy is over $50,000. So, for my electronic suppliers that are on the telephone call, if you guys are selling in mass bulk to potential consumers, there is a potential that, if they have a product quality issue that's not fixed or repaired under warranty, that they could assert a claim in federal court. The significance of this is normally federal court disputes require that the amount in controversy under diversity is $75,000. So there's a lowered amount, and it allows you to get into federal court. You can also assert the claim if you don't have that $50,000 in any state court in the union, and you can bring a breach of the Magnusson-Wasp Warranty Act, which will be interpreted by the state courts. The key with this legislation is, again, they wanted to provide the consumers with a remedy. So if the consumer is successful in asserting a breach of warranty claim and they prevail, they are entitled to receive attorney's fees and reasonable costs of the suit. So that's important, because what has happened with this legislation, as we'll talk as we move through this, is we find that in some instances, consumers have perhaps taken this to an extreme, and they have maybe a breach of warranty that's the value of that dollar breach is not that much, but then they run up a six-figure plus attorney's fee bill to bring it. Courts are allowing them to recover those attorney's fees within reason, and so it's something that the manufacturers and distributors need to be aware of. As far as the definitions, this is important because people often, get this confused. A consumer is a buyer of consumer goods for personal use. Okay, so this again is designed to protect the ultimate consumer. Therefore, if I have manufacturers on the phone, if you're selling to distributors, there's an argument that your actual end user is not who you're selling to. And we'll talk about that as we move through that. Doesn't mean you don't have to comply with Mag-Moss, but means that you might have some other available defenses. A supplier is any person engaged in the business of making consumer products, directly or indirectly available to the consumer. And a warrantor is any supplier or other person who gives or offers a written warranty or who has an obligation under an implied warranty. Consumer product, it's the gamut, right? It's generally any tangible personal property for sale that is normally used for personal, family, or household purposes. Written warranty is an express warranty, okay? So this is another place that a lot of clients trip up on. It has to be in writing and it has to set forth what it covers. I've heard oftentimes, clients come back and say, well, I gave them the warranty, but then I said I'd extend it and I gave them another piece of paper. And so there becomes a question as to whether or not that extension is actually a valid extension and how that works. We'll talk a little bit about that later. And then implied warranty is one that is not written, but it is implied pursuant to the sale. And that generally is governed exclusively by state law. There is some limitations in the Magnusson Act that says that you cannot limit the duration of an implied warranty. And so we can talk about that in a little bit more detail, but generally that provision is strictly interpreted by state law. The important thing about the implied warranty, which is generally something that is provided at the time of sale, just like the express warranty, is that it's not limited in the Magnusson Act. So if you provide a full warranty with the product, the Magnusson Act does not allow you to limit the implied warranty. A limited warranty is generally determined as one that does not meet the federal minimum. So in certain circumstances, you'll have a general warranty or what we call a full warranty. In other circumstances, you'll have a limited warranty. Sellers that provide a limited warranty cannot disclaim them, generally with respect to the terms of the federal Magnusson Act. And full warranties must be designated conspicuously and must say that it indeed is a full warranty. So how can we convey the warranty? Depending on how you distribute your product, how you sell it, you normally convey it in what we call hard copy, either in the packaging that's sold with it or in some other form at the time that the product is sold. So if I'm selling, some emergency beacons, for example, I might include the hard copy warranty in the emergency beacon box that is ultimately sold. If I'm doing it in a little bit more volume perhaps, or if I'm doing it with packaging that maybe wouldn't support potentially writing a full couple pieces of paper and including it. In 2015, President Obama signed into law what we call the E-Warranty Act. And this is an actual good thing because it allows manufacturers your choice to go ahead and display the warranty online as long as you tell your consumers where it can be located. So in the packaging, instead of having to include the actual warranty, if you either put it on your website or you give some indication to the consumer where it could be located, that's going to suffice under the Warranty Act, E-Warranty Act. Interestingly enough, this was passed because, at least in one part, because they wanted to cut down on the use of paper. We did an update when this was issued back in 2016 about the E-Warranty Act. And so that I show on the screen because that is available on our K&L Gates Hub, which I'm happy to circulate if you want to get more details about the E-Warranty Act, but it goes through what you can and can't do and what you should do as it relates to making sure the warranty is available online. So let's talk about an express warranty, right? You've got a product, you're selling it, you do want to provide a warranty, right? For everyone on the phone, generally warranties are derivative of what your actual sales price or sales amount is for your product, right? So depending on the product you're selling, we certainly argue as counsel for manufacturers that the value of that warranty is incorporated in what we're selling, okay? So if you have various claims in the industry or out in the field rather for a particular product, that is noted against the product that you have, and it's a way for you to track product quality, etc. But there's some key things that you want to make sure that you do, right? So you want to stand behind your product because that's the right thing to do, but you also don't want to open yourself up to frivolous lawsuits, and you want to try to, as best as possible, what we call cut off the tail, if you will, of that product value to the company. So one thing we definitely encourage is for you to limit your incidental and consequential damages to the extent allowed by law. And so what that means is if for some reason there is a breach of warranty, you've limited your exposure to what we say, could be things that kind of flow from the breach, if you will. So if the consumer says, you sold me a defective product, I'll use in this instance a boat, the boat didn't work, I now want to, you know, sue you for breach of warranty because you have not been able to repair it. If your warranty stands up in court, you may lose the breach of warranty claim, but you will limit their damages if you have a proper disclosure. And that is very important. Also, you want to explicitly exclude coverage for products and components that are not manufactured by you. So for the people, you know, on the phone, to the extent that there's any electronics that are being built or sold that are eventually integrated, or you anticipate they might be integrated into a bigger product, or they might interface with another product, you want to make sure that you have something in that warranty that excludes any issues that relate to that other product. Also, you want to exclude any type of abuse, misuse, and accidents that happen to the product. You want to basically limit that type of damage when the product is outside of your control. You also want to limit the duration, right? This goes back to the comment that I made before about what you're selling and what the value of that warranty is to the company. So, you know, if you want to give a limited warranty for, you know, a year or a year and a half, that's fine. You know, maybe you extend it for 2. Those decisions are generally based on your particular business model. So who's doing what in the field that's a competitor for you, and how do you do that? We always recommend, you know, if you can limit the duration, it basically follows the life cycle of the product itself. And if you can limit it, it's a way to just limit your exposure within reason. Also limit what you will do. A lot of times I see warranties, and I have to tell you, I've seen a lot of warranties. I've seen warranties on items that I've purchased myself. It is sort of interesting to see them, because I would say that 90% of the warranties that I see will fail if they're challenged in court, you know, of sort of the general consumer products. And maybe that number's high, but from what I've been exposed to, I think that they generally will fail. There's just little nuances that aren't identified. And I also think one of the big things is they don't actually say what they're going to do for you, right? Are we going to repair or replace this if something goes wrong? Or what are we actually going to do for the consumer on this product? So that's also something to keep in mind. Also, depending on your product, and I can't really tell from the calls here, I'm not sure about the tough skin product, but you know, whether you have a transferability option is you know, a question that you need to make a decision on. If you can limit it, we recommend that you do limit it, right? So you don't have exposure beyond your first retail customer. But again, that's driven by the market. It's driven by your competitors and what they're doing. You also want to expressly state what voids the warranty, right? You want to sit down and think about, you want to look at your product claims, you want to verify what's been happening in the field, and you want to determine whether this is something that you want to include in the warranty and how best to do that. You know, a lot of times I believe businesses think that they can just shove everything into warranty and as long as it's there, it works. It's not correct. You know, you really need some guidance on how to best word things to make sure. The good news is once you have a pretty tough warranty in place that complies with all certainly the federal laws in your most of the states, you know, you're in good shape. And really, as far as updating that, it's not done that often unless there's a real significant change in the legislation, and there really hasn't been. And you always want to emphasize key terms, right? Bold them, put them in caps. In the state of Florida, for example, if you're limiting incidental and consequential damages, it has to be in all caps and bold and very conspicuous in the warranty itself. So common scenarios that trigger lawsuits. Let me ask you before we move into this, does anyone have any questions so far?
So,
Okay.
Christina,
Oh, yeah.
Actually, if someone else had a question, they can ask it before me. I don't want to take time from the participants.
Hi, Christina. This is Kat. When you talked about limiting the incidental or consequential damages, what kind of language do you use? Do you limit to actual or direct costs?
Yeah, so there's some verbiage that we include, but we generally keep it a little broad. It's basically any incidental and consequential damages that would flow from the breach. And there's some pretty specific language in Florida that it's basically about 2 sentences, and I'm happy to circulate some of that following the call. But that's kept a little broader, and that gives us a benefit on 2 forms. One is the courts in Florida are pretty good about understanding that if we don't designate it as a damage, which we don't, the idea of a manufacturer's warranty is we tell them what we're going to do, right? We're either going to repair or we're going to replace the product. And anything beyond that, you lost, time from, whatever it might be. When the beacon was out, you couldn't go out on, like, let's say a boat, or you couldn't use a particular facility, whatever it might be. We don't include that. And so judges are pretty good about determining what the incidental and consequential damages are. And so they're really not just actual, they're all damages that are not provided for in the warranty.
Okay, great. Thank you.
Mm-hmm. Okay, so do we have another question, or I'll move into the next?
Christina, this is Matt. I think it was on the previous slide. You had mentioned something about, you've seen language, I believe, in warranties that, are not, written properly. It wouldn't hold up. Something.
Yes.
Can you maybe give some examples of what you've seen in terms of that?
Sure. I can give you a quick anecdote that's pretty recent. I reviewed a bicycle warranty. So this was a recreational bicycle that was sold in the United States by a distributor. It was manufactured in China and sold here, and it was warranted by the distributor, not the manufacturer. And they did not have a clear language to sort of limit incident or consequential damages. They also interchangeably used, terms that wasn't clear whether they were offering a full or a limited warranty. There was no specifics on what actually the duration was. And then there was some pretty specific requirements about having to go to a certain, location for repair. Those are generally okay to do, but they have to be within reason, right? So if I buy a bike that's sold in the state of Florida, you can't tell me that the only way to get service on that bike is to go to, New York or to go to different places. I see that all the time, and I think that's going to be challenged. And the key is, when a consumer is successful in challenging the terms of your warranty, the court, more likely than not, is going to throw the warranty out, which means that all of your state law provisions that allow for incidental and consequential damages, you might open yourself up to potential fraudulent, deceptive, unfair trade practices claims, right? Those all come into play when that warranty doesn't stick. And so, a lot of times, and I just think all businesses, not all businesses, but a fair amount of businesses say, oh, here's what we want to warrant, and we're just going to kind of write it down on paper. And they don't really get any guidance on how to do that. And because they haven't been sued, they think things are going well. But it really only takes that one lawsuit, and things really change for the company and their product.
Okay, great. Thank you.
Welcome. So common scenarios that we see, again, it's dependent on the product, right? If you have, a lot of times when we're dealing with personal consumer use products, especially as they get more expensive, sometimes we have buyer's remorse, right? There's nothing particularly wrong with the product. They just don't want it. And they start digging up things that they want to try to get out of their purchase. Unfamiliarity with product use. I've seen this quite frequently. The more complicated the products are, users try to, manipulate them, and they don't want to use their owner's manuals. They don't want to follow instructions. They think it should be really a plug and play. And when they become frustrated because it's not operating like they should, they try to go back to the manufacturer for relief. Also, unrealistic expectations, right? I mean, if we shift back to, you know, sort of the boating or the car industry, if you look at those two to be specific, you know, a lot of people think I'm going to buy a $150,000 boat, for example, and I'm going to get in it and I'm going to start it up and it's going to go just like my car, right? And I'm going to be able to operate it and there's not going to be any issues. And that's just, you know, unrealistic. Or I bought a product and, you know, it should do X, Y, and Z. It should have this type of light, you know, range. It should have this, even though it's not necessarily what was provided with the product. Economic distress. So one of the things that, you know, I'm sort of previewing for several of my clients now is I have a strong feeling that we're going to have a wave of consumer litigation related to people that are in economic distress, meaning that they don't, you know, for whatever reason, either can't afford to deal with the product anymore, and they're going to be coming back to the manufacturers for relief. In those situations, the economic distress cases, most plaintiffs' firms who take on these types of cases do it on a pure contingency basis. So there is usually no skin off of the consumer's back to reach out to a plaintiff and get them to file cases. Lack of proper maintenance is also one of the issues, whether it's a care guide that you supply with your product, things they should do to ensure that it works over time. We see that frequently where they just haven't followed it. And so they get frustrated when there's an issue with the product and they bring a suit. Also, perceived poor customer service. I, you know, go back to sort of that bike situation, which honestly affected me personally. I bought a really cool BMX bike. My son bought it for himself, saved up all his money, bought this bike. And from literally, I would say, within 30 days of ownership, the bike started falling apart, which was like, I couldn't believe it, right? It was assembled by, you know, their people and it started falling apart. So, you know, I'm a fix-it type of person. I get out, I fix it, you know, try to tighten it up, and the thing won't stay together to the point where my son's riding it and the whole bike falls apart, right? So I calmly call up and say, listen, got your warranty, you know, understand you want me to bring it in somewhere, but want you to know that I don't think that's a sufficient response given the fact that the bike essentially fell apart from day one. And to tell you that their customer service was poor would be an understatement, right? They were negative. They were, you know, we're in the middle of COVID and the only activity that lots of kids can do is bike ride. And as a result of that, it really escalated the situation needlessly, right? And so that is something that can cause lawsuits. Breach of, you know, claims that we see in these. So it's not just the federal Magnusson Moss Act that they decide to sue you for. They bring various different claims, and the first and primary claims that we see after the Mag Moss Act is breach of express and implied warranties under state law or the Uniform Commercial Code. So every state, no matter where you're selling or distributing to, have usually their own set of consumer protection laws. And in those situations, there is an entitlement sometimes to various relief. Generally, however, those statutes don't include a right to attorney's fees. They include other remedies, but not a right to attorney's fees. And so that's where the Mag Moss Act comes in and why they couple them. A breach of express and implied warranty under Mag Moss does allow for attorney's fees. And then they also assume or assert usually a breach of contract or rescission claim. So if they purchased it and you know, their claim is it was defective, they usually ask for a return of the value of the monies. They also bring various fraud claims. So usually, and I've seen this in products ranging in various, you know, levels of value, they will say, not only, you know, did you not meet the terms of your warranty, but when you sold this product to me, it was defective and therefore you violated the Uniform Deceptive and Trade Practices Act. In Florida, we call it FDUPTA, but that's a common statute around the country. It varies, you know, per state, but basically that statute too allows for attorney's fees and sometimes can allow for treble damages. So that means, for example, if your breach value is 10,000, the court can multiply that up, to perhaps 30,000 if they believe there was fraudulent conduct. And then you have your consumer fraud claims, which are, sort of a spinoff of the statutory FDUCTA claims, but they too can allow for attorney's fees and double or treble damages. Those are common claims that will get pled with a Magnusson claim, and it really doesn't matter if the value of your product when you sold it was $100 or if it was $100,000. Those are the claims that you'll see filed. So let's talk about a couple cases. What I did is I pulled several cases. I, of course, have had many cases here, and I've also had cases outside of Florida. These are some of the reported cases that I think can show you when the court takes certain actions and when things go wrong. This case is in the Northern District of Illinois. It was decided in 2015, and it actually was brought as a class action. So for my fellow females on the phone, we're all familiar with Suave. Apparently they had a keratin infusion kit, and the claim was that it was not, it was defective and essentially caused damage to the consumers. The claim that they asserted was under the Magnusson-Moss Warranty Act. And as a result of that, they did prove the breach, and then the case decided what attorney's fees they were entitled to. The attorney's fee demand in that case was $3.4 million. The court, for various reasons, decided on $1.5 million. But the way the court did that is it looked at each individual lawyer, what their billable rate was, it looked at the comparatives in the industry, and rates ranging from $750 an hour all the way down to $200 an hour were deemed to be reasonable in bringing this type of claim. This is a case that that we worked on here in the Southern District back in 2013. I included this case because I will tell you that most of the cases that are brought are able to get, I would say, substantially gutted, is the words I like to use, on a summary motion. Many people, because the act is so, it is so detailed and there's lots of different interpretations depending on where you are, knowing how to get around certain things, once it gets to the lawyer stage is helpful. And so I would say a lot of the cases get granted on summary judgment, not outright, but the goal would be that the only claim that would ever go to trial is the breach of express warranty claim, right? Did we breach the express warranty? And if we did, what your remedies are. We've had several cases get to that point, and the plaintiffs then decide, well, if I'm only stuck with the warranty and what it provides, it doesn't provide me anything, so I'm out of luck. And they either go away or they settle it for a very nominal fee. This is a case that was brought by Mr. Ogner, who argued that my client, Searay Boats, had provided him an extended warranty. I had talked about this a little bit before. And his idea of an extended warranty was an email that he had received from a service rep. And so he said that the email indicated that his manufacturer's warranty, which was a hard copy warranty that was distributed with the product, was extended. It didn't say that, and that wasn't the intent of the email. But on face value, Mr. Ogner had somewhat of an argument. The problem with that is that the law doesn't support that. The law does not allow for extensions of warranty pursuant to emails or otherwise verbal conversations. And Judge Moore in the Southern District agreed with my argument there and essentially dismissed the case. It has to. He also argued that the idea of a warranty is one that's provided in connection with the sale, right? So if you decide to do something 6 to 8 months later, we're not talking about the original warranty. We're talking about something different. And so you could not be held accountable under the various acts. This is a case against Ford Motor Company in the Southern District of Florida in 2014. This is interesting because of the language that's included in it, which the court basically said a repair or replace warranty cannot fail if the manufacturer is willing and able to fix the deficiencies. So an example, let's take a car, for example. Everyone knows, I have a steering pump, I have brake lines, you know, I start having problems with the car. I have the brake lines go, I have the steering pump, I have, you know, as long as the manufacturer is standing behind the product and making those repairs to the various things that are occurring, you're not going to be in breach of warranty. The problem is when that brake line, right, can't be fixed, and you make several attempts to fix it and you're not able to do it, or the car goes in for repair and it sits in the repair shop an inordinate amount of time, and you're still not able to repair it. And in those situations, the judge basically is asked to decide, you know, does this warranty really work, right? Under these circumstances. The other thing that was interesting in this case is the court said that design defects can be covered by an express warranty if not excluded. So this was extremely favorable to this manufacturer, because basically what it held was, hey, you know, you actually might have a product quality issue and it might be related to your design, but if you can fix it, I'm going to allow you to basically enforce your warranty. And I'm not going to allow them to get around that. And so that's an interesting scenario, especially when you don't have personal injury. The product itself and the warranty will stand, even if you've got a design defect. And I think that's very favorable to manufacturers. Also, including a prerequisite dispute claim process is okay. So if you want to require that they first go to some type of arbitration, we can talk about that in more detail because there's pros and cons of that. But if you do want to require that, it's okay to tell the consumer that when they get the warranty. This is another case. It was just recently decided. In fact, I think these arguments were, I held just after COVID broke in the Southern District of Florida with Judge Ruiz. This is a situation where the judge ruled that privity was required for breach of implied warranty claim. So big picture here, you have an express warranty claim, right, that tries to disclaim and limit your damages only to repair or replace. And then you have the state law that allows claims for breach of implied warranty. The courts have kind of bounced around on whether a manufacturer can be held responsible for an implied warranty. We've always argued that they cannot, right? Because they're not in direct connection with the ultimate consumer. They usually sell to a dealer. They don't normally sell directly to the consumer. In this case, the judge agreed with me and said, yes, they're not in privity. They're not in that sales transaction. And so I'm not going to allow them to assert implied warranty claims. That was a big deal because it basically cut their damages. Whatever they thought they were going to get, they weren't going to get at that point. He also ruled that, this was interesting, the plaintiffs filed a claim, and then they sort of decided after they filed their claim that they would go out and figure out what was wrong with the product, right? And they did a whole bunch of investigation and hired a bunch of experts and came back and said, all these things are wrong. And we simply said to them, well, that's nice, but we have a warranty, and the process is you need to tell us what's wrong and give us an opportunity to repair it. And they're like, yep, fungal, we're going forward. Well, you'll see what happened. The judge said, no, you can't do that. They told you it's a warranty. You have to give them an opportunity to repair or replace. You don't get to say, I've got all these different issues without any notice. And that also substantially gutted their case. This was a claim for about $1 million, and I think the settlement was less than 6 figures. Implications to manufacturers. So what can you do? How does this legislation impact you, and what are things that you can do to sort of enhance? We talked about the terms, key terms and warranties already. We talked about how you convey it, right? You want to make sure it gets to the customer. You can keep good records of the product, the warranty history and the manufacturing documents. Make sure that you have all those in some type of either document retention or somewhere in the company that it can be located. You always want to keep your testing and quality documents. If you're manufacturing, I don't know if you're distributing those beacons or you're manufacturing them or both. Make sure that you keep your testing and quality documents. If they have any type of requirement, either UL or various things that you have to comply with, make sure that you have a note in your file that you've done that. Send clear messages to the consumer about your product quality and set firm standards, right? You know, this is what we're selling you. This is the warranty that goes with it. And we're going to stand behind it, you know, and that's why we're offering that warranty to you. Now, that does not mean that you have a consumer that comes to you and says, I understand that this is what your warranty says, but this is what's happened to me, and I'd like you to make a consideration to give you some goodwill help. Manufacturers do that all the time. They say, okay, you're right, it's not covered under warranty, but you know what, we're going to send you out this part and we're going to do it by goodwill. If that happens though, please make sure that you note in your warranty history that you're sending it out and it is quote unquote goodwill. I've seen arguments made by consumers that say, well, he sent that to me and so it must have meant that it was still under warranty. And so, you know, having that documented is important. Know when to spot, you know, concerns with customers early, right? You know, again, this depends on the nature of your business. Some of you might not be involved in the end user, but if you have and you can sort of suspect that there might be issues, you know, flag the file, pay attention to it, watch what happens with that particular claim. Documenting your files, we talked about tracking the history. That goes back to what I said in the beginning. You're tracking the warranty claims per product so you can get an idea of what it's costing you to service those products under the warranty in the field. That's important too because it can help you spot trends, like I mentioned before. And know when to stop the concessions, right? I mean, there's a time where you need to say enough is enough. We're done with this particular customer, but just make sure that it's done appropriately and within reason and within the terms of your warranty. Communicating with consumers, if you are, you know, dealing with them, you know, you do it in writing and you follow up and you make sure that you close out matters. And it's always necessary to do that. And I have this in red because a lot of times I see issues started and they're not completed. Things fester. People think because the person's quiet that they're not going to come around. They then come around and you don't have a paper trail to show that you saw the issue through to the end. We talked about providing clear and concise warranties. So, you know, Matt, I think you asked me about, you know, some of the things that I've seen. I've also seen just misorder of information and warranties that do not make them clear. If you give a judge an opportunity to look at your warranty and they can't tell what you're trying to provide to the consumer, your warranty is not going to stand. It's going to be thrown out. Make sure you're labeling the warranty, full or limited. Expressly limit the incidental or consequential damages. You can provide the warranty in either hard copy or electronically, and don't overcomplicate the warranty. Please, whatever you do, you know, 1 or 2 pages should suffice. It's not, you don't put in there every time that there's been a product quality issue and try to exclude it. You think smartly about what you want to include in there and you do it. But you make it so that it is a simple conveyance of information for a reasonable consumer to understand. Avoid claims by using trained and dedicated customer service people, right? I mean, there's going to be times where they've got to make unique decisions. That job, you know, if you're running a business or an organization, that person that's interfacing that really is dependent on your business, and it impacts how you're able to conduct your business, right? If you have a guy or gal sitting in that position who is abrupt and they're not handling things correctly, that's going to come back to you. You know, I put that little bike there. That's kind of the look of the bike that it was. I was really astonished. I will tell you that ultimately the resolution was they did wake up. I say they cleared their eyes a little bit and said, what are we doing, right? We need to do the right thing. And they ultimately did, but it was a little bit of a struggle, and it shouldn't have been. It should have been a more easier approach under the circumstances. So I would say be responsive and understanding, you know, especially now, we're in unique times. People are going to ask for, you know, different things. If you can do it, and it doesn't really, you know, take too much off of you to do it, maybe you should. There's some things that should be considered. We talk about temperament and a major factor. I can't tell you how many lawsuits that have come to my desk where it's basically one person in a contest with the other person, and it's gotten to where it's gotten, and it makes no sense, none at all. And it's just a, sort of division of mindset on a particular issue, and it gets out of control. So if you can avoid that, try. Some of that can't be avoided, which is understandable. And make sure you're documenting all your interactions with customers in your database or in some type of transaction log. Look, depending on your business, you may or may not do this, right? I'm going to tell you, right, and this is not, whether it's me or it's one of my other bar members or who it might ever be, have someone review your warranty that knows what they're doing. It's going to save you in the long run. You're going to know that you can stand behind things. You're going to feel comfortable about the terms of your warranty when consumers are calling you screaming, and you can say, listen, this is the warranty, we're happy to do X, Y, and Z, but these are the terms. I think that's important. And I think a lot of times the legal spend to do that, it's not that much. And manufacturers sometimes say, well, we're just not going to do it because we really haven't had any lawsuits. Or, well, we're just not going to do it because we don't think this is the product that people are going to sue on. You just never know. And the more your business evolves, the more important it is to have that reviewed. And, it's also good to consult with someone. A lot of my clients call when they have a hairy customer situation, right? They've got something going on, and they want to know how to approach it. They want to temper it down. And that's what we like, actually, the front end of the business and getting involved in sort of helping you resolve those issues without avoiding, with avoiding having to go into litigation or some type of formal dispute is what we want to do. So what I've said a lot of times, and what I do is I ghostwrite letters, I ghostwrite emails. I help the client through situations that could become worse and sort of guide them so we don't get a lawsuit. And so that's something that you might want to consider doing with your respective counsels is, if that's happening, get them involved, get some insight, what can be helpful. And that's it. If you have any other questions, I'm happy to address them.
Christina, in talking about warranties, how do U.S. warranty laws coincide with the UK Sale of Goods Act?
Yeah, so that's a good question. I have not actually had to deal with the UK Sale of Goods Act, but I can tell you that generally my understanding is they are very different. And the US, at least from the partners that I deal with in my UK office, the US, they feel have more requirements, but I have not personally had to deal with that UK Act, review it myself. I have not. I've had matters in Europe, I've had claims in Italy, but I have not had to deal with that particular act.
Okay, thank you.
Mm-hmm. Anyone else? Any other questions? I'm happy to, if anyone has any questions following this, if you want to give me a quick call, I'm happy to address anything that you may need going forward. Please feel free to reach out. And it was a pleasure speaking to everyone today.
Great. And Christina, thank you for doing this. If there aren't any other further questions, Christina, for the group here, and we can send your contact information out for those that participated, but if you could just share with your email for the group, for those that
Sure.
can maybe jot it down.
Sure, it's Christina, CHRISTINA.Paul, PAUL, at K like kangaroo, L like Larry, Gates, GATES.com.
Great, thank you, Christina.
Yeah,
and just one final piece of information. Does anybody else have questions before we officially close the webinar? Maybe someone was on mute and was trying to unmute themselves. No? Okay. Well, we thank you again, Christina, for doing this. Very insightful. I hope those on the call today also found it very insightful. Again, if you have questions that you think about after we close, please email Christina. If you need her contact information, you can email myself or Caitlin. We can get you over that information. And this is just a sample. And for those on the call, you'll see a lot more of this type of information coming to you. Myself, Caitlin, Jay Hess, who's one of our business advisors, and Micah Doherty, our other business advisor, are really, what we're doing now is creating a guide to operational normalcy for the COVID, and we're creating a recovery stage, phased-in approach, prepare, prevent, respond, recover, and thrive. And the next phase of what we're going to be doing, what we're working on, is really respond, which is a transition to normalcy, return to work. There's going to be numerous series within that part that you will see coming up very soon. But webinars like this and on other topics and maybe other related topics from a legal aspect, you'll see coming out. So stay tuned for that. But we appreciate everyone on the call today taking time, and we hope this was helpful. So thank you, everybody.
Thank you. Have a good day, everyone.